Mr. Nguketobi, I've been following the debate between you and my brother Rogers. I want to take you to certain references in the report itself.
Yes, I need to just get, yes, I'm listening, Justice Matop. I just need to get the full report in front of me.
Well, just find it because I want to draw your attention to certain paragraphs in the report and go through them.
Yes, I've got it now.
Firstly, I kick off with paragraph 72. This is where the panel says, we have compared the terms of reference for this panel to those of the panel established for the removal of public protector. The powers and functions of those panels are substantially the same, save for one noticeable difference. The wording of the terms of reference. The terms of reference for the removal of the public protector require the panel to conduct and finalize a preliminary assessment relating to the motion proposing a Section 194 inquiry to determine whether there is prima facie evidence, to underline it, to show that the holder of a public office is guilty of any offense listed in Section 174. And they say, by contrast, this panel is required to make a recommendation whether sufficient evidence exists to show that the President committed one of those grounds for the removal from the office.
Yes.
But when it goes further, it conflates this test. It talks about prima facie evidence. If you look at paragraph 75,
Yes.
That's where the prima facie evidence comes into the fore. Paragraph 75, paragraph 76, that follows. Now, one is left with a misapprehension as to exactly what test is the panel following and applying. Because clearly sufficient evidence, as far as I understand it, is not prima facie evidence. And in the context in which it has been used, the panel specifically made that distinction in paragraph 74 to say, we are now dealing with two distinct concepts.
Yes.
But when you read paragraph 75 and paragraph 72, there is a conflation.
Yes.
What are we to make of that?
Well, there are two ways of reading this report, maybe three if you listen to Justice Rogers. But I submit that there are two ways of reading the report. The first one is a fundamental misapprehension of the terms of reference. Right? It's told, go and find sufficient evidence. Then it decides it's not going to do that. It will do something different. And that's a misapprehension as to power, and therefore, on the jurisdictional facts standard, Panama is entitled to say, we're not going to follow an error of law. The second one is that there is a fundamental confusion in the analysis of the report, because firstly, it recognizes what it is required to do, and throughout the balance of the report, keeps conflating the two as opposed to separating them. On either of them, whether or not what I have tried to suggest to the court is illustrative of a misapprehension as to the correct legal test, or it is illustrative of deep-seated confusion. On either of those two, the Parliament was entitled to refuse to go along with it. The third possibility is what I've been discussing with Justice Rogers, if I understand him correctly, which is forget the nomenclature that is apparent in the report, do an analysis on your own. And what conclusion do you arrive at if you do your own analysis? Now, that is a very, very dangerous thing to do, because it is not your function to recast the report on behalf of the panel. It is not your function to place yourselves in the position of members of parliament. You have to accept the report as it is, accept the members of parliament as they are, not to rewrite it for them. I don't know how many other reports you'll do this for.
Is it correct that the panel information, I use the word guardedly,
Yes.
information regarding the report, the compilation of the report, the information was scanty, or it did not have sufficient information. I'll read to you paragraph 80. Just look at paragraph 80 of the report. It says, we are concerned that we have not been given all the information that is presently available on the Phala issue. Just stop there.
Yes.
And this and it lists a various institutions that are investigating the case. In other words, they are saying we are hamstrung in our investigations. We are unable to come to a proper and justiciable finding because we don't have information. Is that
Yes.
assumption correct?
Yes, no, it is correct, and in fact, it's stronger, Justice Matopa, because it's precisely what Minister Lamola says. Remember that he was criticized by the ATM for taking into account this fact, because he also says, look, you have told us you don't have enough information to come to the conclusions, but nevertheless, you've come to the conclusions. And these inquiries, are pertinent. We now know with the benefit of hindsight. At the time that Mr. Lamola spoke, he only knew of one, which was this Mr. Hazim Mustafa that was said to not exist, in fact does exist. And then he said it's very, very dangerous to put the president through this on the basis of scanty information, because what that really does is that this becomes a fishing expedition. So it's correct that they themselves admitted that they did not have sufficient information.
In the bigger scheme of things, a panel confronted with a report or an investigation of that nature, I don't understand why they didn't ask for an extension.
Yes, in fact,
They make the point somewhere in the report that they are operating under serious time constraints. I will look for the reference.
yes, in fact, I think it's one of the criticisms by Minister Lamola, who says he doesn't understand. He doesn't understand why they. Oh yes, it's at 956E. So if you look at 956E, 1, 2, 3, 4. 956E. So he says. Two, the panel could have requested an extension of the time period to finalize this report, which it only did once. The Zondo Commission requested extensions till we got tired. All right, anyway, the point is made.
Well, the last paragraph that I want to draw your attention to and ask for your comment is paragraph 82 of the same report. There they said, that said, we believe the truth of what really happened lies beneath the unanswered questions that are foreshadowed by what we are told from the information placed before us. We neither have the tools nor the power to excavate beneath the information that we have been provided with to uncover the answer to the unanswered questions. However, based on what we have been told by the information placed before us, the information that is either common cause or undisputed, as well as inherent probabilities, we are able to make our finding and provide reasons therefore, and make our recommendation.
Yes. It's illustrative of the bigger problem that although the panel claims to appreciate the momentous nature of the function before it, it didn't actually carry through that concern. Because if it claims, firstly, not to have enough information, and secondly, not to have the tools to get enough information, not to even ask for Parliament's assistance, because it would have been entitled to ask for Parliament's assistance, not to even ask for an extension. And then to simply say, no, we'll just make do with what we have. So that we would say is itself, as Minister Lamola pointed out, evidence of a misdirection.
Thank you, Chief Justice.